The way to do that is to hire counsel very, very quickly. We're the armed attorneys. Today we're talking about no bills. We're going to address questions like, what is an indictment? What's a grand jury? What does it mean to be no-billed? How do you increase your odds of being no-billed? And is a no-bill the end of the story, the end of your case? But before we get rolling, show your support for the Second Amendment by hitting the like button and consider becoming a channel member, linked in the description below.
Brings us to our first question, which is, what is an indictment? An indictment is a formal charging instrument, usually brought in the name of the state, commonwealth, or the people, against a criminal suspect, and it lays out the particulars about, an alleged criminal offense that they committed. Now, in most states in the United States, that's how most people are charged formally in a criminal setting, especially for felonies. But that brings up this kind of process of a grand jury that we see on TV. A ton of states use the grand jury system. And what is a grand jury?
Yeah, so, and again, most states use grand juries, or not all, but a grand jury, they're going to be summoned in a variety of different ways. Some grand juries are summoned just like, when you get your regular jury summons, except they meet for much longer periods of time, and their only job is to issue indictments or no bills, right, which is the lack of an indictment. So some states, though, in Texas, I know for a very long time, the most prominent way to summon a grand jury was basically a buddy system. Like the county could go out and just kind of pick and choose their grand jurors, which is not a good way to do it. But they get summoned in all sorts of different ways. They meet, they consider the case, they decide whether there's enough evidence to actually go forward with a formal charging instrument. And typically these proceedings are secret.
Yes.
Right?
And the standard that the grand jury, when you have your criminal trial, the standard that the state is held to is they must prove the case beyond a reasonable doubt, unanimous jury verdict, in order to secure a conviction, essentially. Grand jurors, much lower standard. The standard typically is probable cause, and that's what we see over and over, and it doesn't have to be unanimous. Let's say there were 12 grand jurors, maybe 10 just to have, that's all that's required to find probable cause in order to secure an indictment. And if you've heard that term, I could indict a ham sandwich, it really can be that easy. The indictment process, for the most part, is kind of a rubber stamp deal, but there are ways to increase the chances. And what got us talking about this, because grand juries are the ones issuing these indictments, was the Kyle Carruth case. That's the Lubbock case where person came over, alleged custody dispute, and it ended in a person being shot and killed. But he was no billed, and so that we kind of got all these questions of, when do these no bills keep coming up? Let's talk about them. But what would you say to your client who says, hey, I want to increase my chances of getting a no bill? What would you say to them?
The way to do that is to hire counsel very, very quickly, because, and every state is a little bit different, but, I would say most states, there's going to be some kind of mechanism by which the defense can participate in this process somehow. Here in Texas, they let us do it by grand jury packets. So basically we prepare written materials. They're going to tell our side of the story, basically. That's very, very good information. Sometimes they want the defendant to actually come testify. And if you're going to go testify in front of a grand jury deciding whether or not to indict you, you need to be well prepared by a really good criminal defense attorney, because even though those proceedings are generally secret, right, they are still recorded, and you're sworn in and you're under oath, which means something very important. It means that all of the testimony that you give as the criminal defendant can be used later, if you are indicted, to cross-examine you. So if you say the wrong thing, not only could that get you indicted, but it could be really, really bad for you at trial.
But what happens if you are indicted, Emily?
Yeah, so it's not the be all and end all. That just means you've been formally charged, which if you've been arrested, you probably know is coming anyway, and you're probably expecting. The indictment is not evidence against you, right? That is just your formal charging instrument. It simply means the state gets to move forward with charges, and your case is probably going to see a petit jury, right? That's your trial jury. So it's being indicted sounds very, very scary. Really, all that means is there's enough probable cause that you could be formally charged and your case proceeds forward to trial.
Yeah. And what comes up from time to time, and I talk to clients about this, hey, we just got a no bill. Great. Is that the end of the story? And unfortunately, the answer is sometimes no. For certain charges, there are no statute of limitations. Murder is a great example. In most states, there's no statute of limitations for murder. So that means the state could theoretically at any point in time decide, hey, we're going to bring this charge back and we're going to attempt to prosecute this person. But there are some limitations. There usually has to be some material change in the case in order to kind of spur this process again. So typically new evidence, or a witness comes forward, or something like that to kind of get the wheels spinning again. But to those clients who talk to you, Emily, and when they say, hey, I'm all done, right? Or maybe they want to get an expunction, what do you tell them?
Yeah, so no, not only are you not all done on the criminal side, particularly if the charge is murder, for which there's no statute of limitations in any state that I know of, but also your civil liability, it's completely unaffected by that no bill, basically. So could it possibly be good evidence in your civil case that you didn't do anything wrong?
Yes.
Sure. Will it stop you from being sued? Will it stop any of the proceedings from moving forward? In most states, the answer is no. So maybe, best case scenario, you get a no bill, you've won half the battle, right? And that's the best case scenario. So unfortunately, it is, it's the best thing we can hope for. And yet still, we always say staying out of these situations, not being arrested in the first place is the best thing you could possibly do, the best way to keep yourself safe, because even in the, chance that you go to a grand jury, the grand jury says, oh no, Richard didn't do anything wrong here, he gets a no bill. Well, Richard's life is still very, very difficult for the foreseeable future.
Yeah. And there are a lot of variations between the states. Like some states do have a pretrial immunity hearing, but this does pop up over and over, and it's a good topic to know. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight that anti-2A algorithm by sharing this video.
And please continue to question and comment below. Until next time, we're the Armed Attorneys.